messed it up.
Okay, so before we start our meeting, I wanted to acknowledge our two guests, or three guests really. Patricia is here thank you for coming, Patricia.
Thank you.
Terry is here. And I will be introducing our speaker later, and that's Jarratt Martin, who will be speaking as soon as we get over this beginning. Okay. Okay, this time we're going to do, oh wait, first we'll start. Okay, first we're going to do the Pledge of Allegiance, but I have some special people doing it, so I would either put it on mute or don't say the Pledge of Allegiance, because I have some special people that are going to do it for us right now. I hope you can hear it.
I pledge allegiance
to the flag
of the United States
of America
and to the republic
for which it stands,
one nation, under God,
indivisible, with liberty
and justice
for all.
All right. Now, wasn't that nice? Okay, I'm going to read the prayer for today. For some reason, Bill didn't make it. As we gather here today as members of Rotary, we pray that we are ever mindful of opportunities to render our service to fellow citizens and to our community. Keeping in mind always the enduring values of life, exerting our efforts in those areas and on those things upon which future generations can build with confidence. Let us continue to strive to make a better world. Amen. Okay, the next is Jerry. You want to do the thought of the day?
Thought of the day. Those who can laugh without cause have either found the true meaning of happiness or have gone stark raving mad. Norm Peppernick.
Okay. All right.
There's no reaction because everybody is mute.
Everybody's muted. Okay. Before I go off on the speaker today, Rebecca, do you have anything you want to say? No? Okay.
We could probably save it for afterwards, but I was going to have Dave speak about the call that we were on last night in regards to membership and
Okay.
moving forward and so forth.
Okay. All right, great. Okay, Jennifer, and just to let you know, you can share the screen if you want. I'm going to introduce Jennifer right now. Jarratt Martin is a partner of Jarratt Martin Law, an estate planning, mediation, and family law firm in Pleasanton. Her practice focuses on estate planning, probate, and trust administration, and the probate litigation. Jennifer works with clients to develop comprehensive estate plans so that they can secure their families' financial futures. She also helps families dealing with inheritance disputes sort out their issues in litigation. Jennifer uses her BA in mathematics from UC Berkeley and her JD from Rutgers to navigate complicated financial issues and help clients figure out solutions that work for them. Jennifer enjoys sharing her knowledge about estate planning with organizations and groups across the Bay Area. And I think she spoke to us when we were actually at the Fish Market and had an in-person meeting. Oh, good. So Jennifer's going to give us the lowdown on Prop 19. Take it away.
Thank you so much for the very kind introduction, Brian, and thank you so much for having me. I've been asked today to talk to you about Prop 19 in addition to sort of more general estate planning concepts, but we'll see how far we get about Prop 19. If there's a lot of questions, I'm happy just to focus on that today. So I'm calling this Prop 19 the good, the bad, and the ugly, and that's because there's a lot of good things about Prop 19. There's some not so great things, and there's a lot of ugliness in terms of what are we going to do with this new law. So let's kind of get our bearings, because we want to talk about what used to exist so that we can understand what Prop 19 has done to change the landscape. So before we had Prop 19, we had previous laws about the homeowner's property tax basis and how that was calculated. So we had Prop 60 from 1986, where if you were a homeowner age 55 or older, that gave you the right to transfer the current taxable value for property taxes of your home to a replacement home when you moved. If that home was of equal or lesser value, it was in the same county, and it was purchased within 2 years of you selling your previous home. So basically what we did is we made it easier with Prop 60 for homeowners in California to not have to worry too much about property taxes being reassessed, as long as they met those conditions. And you might look at that, that's pretty stringent. It had to be in the same county, it had to be equal or lesser value, and it had to be bought within 2 years. And then Prop 90 in 1988 changed it a little bit. It made it more generous. It said you could transfer the current taxable value of your original home to a replacement property in another county, but only if that other county said it was okay. And every county made its own choices. I think there were 11 counties in California that said yes. Alameda was one, Santa Clara, I believe, was one, but Contra Costa County, right next door to us in Pleasanton, said, no way, we're not going to accept transfers from another county. That hurts our property tax basis. So we had that situation with, if you were over 55, what happened with your property taxes. And that, as we know, is what let us keep a low property tax basis, keep our property tax bill low every year without worrying about the skyrocketing land values in California. On the other side of the coin, we had rules about what happened if you passed away or gave as a gift your property to your child. So we had Props 58 and 193, and they basically established this. If you were a parent or a grandparent, if you had a predeceased child and now it was going to go directly to your grandchildren, you could transfer your principal residence to a child or grandchild without property tax reassessment. It was called the parent-child or the grandparent-grandchild exclusion. And there were forms you filed with the assessor's office if you gifted the property or after you passed away. There were forms they filed. And the key was this the principal residence for the parent or grandparent? If so, the full value went to the child. They got to basically keep your assessment level for property taxes. They were not reassessed like a person might be if they purchased a new house outright. They would be assessed at the current value of the land. You could also transfer non-residential property, i.e., if you owned rental property, you could transfer it up to $1 million of that property value to your child, or if your child was predeceased, to your grandchild. And again, they were excluded from reassessment. So we had a nice situation going on in the probate or trust administration realm, specifically in that someone would pass away, their house would go to, let's say, their 2 children. Those 2 children would get the house. There would be no property tax reassessment, even if those children kept that as a rental property. They didn't decide to live in it. On the other hand, you could have people transferring multiple pieces of property to their children without reassessment because you had this up to $1 million for other non-main home property, so non-principal residence property. And so there were a lot of transfers of property in California to children that were keeping those very low property tax basis, and they were getting the advantage of the same rules that their parent had been operating under. And this was great for those people who were receiving those properties. Well, then Prop 19 came along. As you may know, we voted on this in the November election and it did pass. It has 2 different effective dates. We're going to talk about the one for people 55 and older first. But it did a few things. So Prop 19 changed a lot of the rules around property tax reassessment and the parent-child exclusion, which we'll talk about in a minute. But for those 55 or older, Prop 19 is great. And the reason it's great is that if you want to move to another county in California, you don't have to worry anymore about whether that new county is one of those 11 counties that said, sure, port your property tax exemption over to us, that's fine. So Contra Costa County doesn't have the discretion to deny that anymore. Across the state of California, if you move anywhere, you get to move to any county, and you get to port your property tax exemption. If the new property that you purchase is a higher value than the property you sold, which we all know can happen because of skyrocketing land prices, especially if you're moving, let's say, into a city closer to, rather than out sort of more rural areas, you're moving closer to the central areas. Even if that home is higher value, you will basically get to keep the old property tax basis on the value up to the value of your old home. And then you will only be paying the higher property tax basis on the difference in value. So that didn't used to be the case, right? It used to be that it had to be of equal or lesser value. Now it can be a higher value property. And for a good portion of it, you can still get that lower property tax basis. And then you can now use this exemption 3 times, not just once. So you get to continue to carry over that exemption through multiple moves. You'll note that it's not just for people age 55 or older. People with severe disabilities, they have the same rules as those 55 or older. Victims of natural disasters, they get to basically take advantage of this one time. And that's because it's designed to say, well, you can move out of the area where there was a natural disaster and you can port your exemption there. But they don't get to take advantage of it in the same way that people 55 or older do. So this is really great. Basically, older homeowners, homeowners with severe disabilities, they have much more flexibility when they move within California. They no longer have to worry about if their new property tax levels will be unaffordable, right? Because they've moved from a county where they've lived there since the 70s and they had a really good property tax basis. Now they've moved to a new county that doesn't accept it, and all of a sudden their property taxes have gone up 3, 4, 5 times as high. So this is really nice for those homeowners age 55 or older. Then we come to the downside. So you knew it was coming. Whenever they give an advantage or they make the law better for one group, they have to figure out how to pay for it for the other group. So, you know, quite maybe reasonably, counties said, but this is going to be a problem for some of us because we didn't allow them to port their exemption before because it was hurting our property tax basis. So you have to give us something back. And so within the same Prop 19, they changed the rules about the parent-child exclusion in a bid to kind of even out the consequences. It's not necessarily going to even them perfectly, but that was at least the intention behind the law. And please note, while the previous one started on April 1st, 2021, so it isn't in effect yet, and we'll talk in a few minutes about what that means. The parent-child exclusion, the old rules ended on February 15th of this year. So we are now under the new regime of rules. But let's talk about that. So they've significantly limited the parent-child and grandparent-grandchild exclusions. They retained the principal residence exemption, but it's not only now that the parent had to use the house as their principal residence, but the child must now use the house as their own principal residence to qualify for the parent-child exclusion from reassessment. So that means that they can no longer use that as rental property and qualify for the exclusion. And even if the property is going to be used as the principal residence on both ends, if it's assessed for more than $1 million over the current taxable value, there's going to be an upward adjustment. Note that this $1 million does scale up with the California House Price Index starting 2023, but it is important to note there are some homeowners that this will apply to. For most people, maybe not, but if you've had if you've owned a property for quite a long time and then it's passed to a child, this might apply to your property. I should note that there'll be a scaling up of the difference over the 1 million, but again, you'll get the better basis on the up to the 1 million, if that makes sense. So what this means on a practical level is there is no longer going to be a parent-child exemption for a non-principal residence. So if you pass away and leave your house to your child, and your child does not want to live there, but they want to maintain the property as rental property, their property is going to be reassessed and they will pay the property tax level as though they had just purchased the property. So that's the downside to Prop 19, one of the aspects that was baked into it. So now we're going to talk about what I'm calling the ugly aspects to Prop 19. And this is where we get into a lot of uncertainty about what this means and what this is going to do. So we talked about a second ago that the reassessment of the non-principal residence properties will absolutely hurt some beneficiaries. Even with rental income that can possibly be generated, the property tax levels might be too high for some of them to keep the properties. So we may see a surge of properties coming onto the market that otherwise would have been kept as rental assets. Then we have the part about the April 1st start date for the new rules for those 55 or older. So there is no definitive guidance that's been released as to whether transactions taking place before April 1st will count for the homeowners over the age 55. Will they be under the old rules or under the new rules? The current guidance that we've received, and when I say guidance, I mean from county assessors' offices as well as from the BOE, but these are not legal regulations that have been put in place yet. It's one of the things that they've asked the legislature to potentially deal with because there's a lot of regulatory framework that was not put into place by Prop 19. The current guidance does suggest that you can either use the date of sale of your old residence or the date of purchase of your replacement residence. So for example, let's say that you are currently in the process of selling your home and purchasing a new home. If you would like to be covered under the new Prop 19 rules, which if you're moving to another county that won't court your exemption, you probably do want to be, you should have either the sale date on your old property or the purchase date on your new property be after April 1st. Even if it's April 1st, you're fine. You can make a very strong, I don't even want to say argument, you can justify it to the assessor's office when you file the paperwork, and your attorney can, or your accountant can do that as well. It's going to be a bit more complicated if you make your sale date March 30th and then try to say, but I should be covered under the new rules because I filed the assessor's paperwork afterwards. So for people in that specific position, it's probably worth it to wait on one side of the transaction, see if you can make an agreement about that. Obviously, people who already sold their home a year ago and filed the paperwork, they're covered under the old rules. Although if they sell their house again, there's some suggestion that you could take advantage of being allowed to port the exemption 3 times, like you would be covered under that portion of it. Again, we don't have definitive rules issued yet on several of these issues. There's probably going to be some litigation. There's probably going to be some rulemaking that has to happen. Some other things, and this is about the parent-child exclusion. There has been very inconsistent guidance about how long this exclusion lasts. So there is a BOE memo that suggests that as long as one qualifying child is still living in the house, even if it's a different child. So you could have a scenario where mom and dad pass away, son moves into the house. 5 years later, son says, I don't want to live in this house anymore, or I have to move for my job to Southern California. And now daughter says, well, you know what? I'll live in that house because I'll sell my house and move into mom and dad's house. The current guidance does suggest that that would be seen as a continuation of the exclusion or exemption period. So even though it isn't the same person who originally made the transaction qualified for the exemption, if another qualifying person moves into the house, the exemption should continue according to the current guidance that we have. Important to note, this has again not been codified in a written law. This is just the interpretation of the lawyers at the BOE about how they are interpreting it. Different counties' assessor's office may choose to interpret it differently, in which case I'm sure we're again going to see some challenges on those issues. Another current thought is that once the qualifying child or every qualifying child vacates the property will be reassessed. So the idea is that the exemption only exists as long as a qualifying child is occupying the property. So if 10 years from now, the person moves out and the property is going to be rented out, at that point, the parent-child exclusion exemption would end and property taxes would be reassessed. Now, the interesting part is the current guidance says that you're not going to be asked to pay back taxes for those 10 years, right? But instead, they're going to reassess it at the level they would have when the parent died. And then going forward, that will be the new property tax basis in the house starting at that year when you vacated and now it's going to become rental property. So there's going to maybe be some complications there. I don't know how easy it's going to be, especially if a long period of time has passed for them to do that. Does this mean that when someone passes away now, we should be having some sort of property tax assessment done? As you may know, a lot of the time we have an assessment of value done for the purposes of dealing with the IRS, but do we need to get one specifically that addresses the property tax value, which, as you know, is not always the same as the actual value of the property for IRS purposes? So that's an open question still. You can see there's a lot of ambiguity left with Prop 19. It has not been clarified in a way. We don't want to blame everything on COVID, but it does seem like COVID has slowed down the issuance of guidelines that would provide some clarity. When I talk about that BOE memo and some of the guidance from the county assessor's office, those came out sort of the second week of January regarding a law that was passed, the first week of November. So there were a good 6 weeks where nobody really knew what was supposed to happen. People rushed out to maybe make transactions that they shouldn't have, or maybe they were good transactions, only time will tell. And we certainly had a lot of people calling my office, worried clients who worried that Prop 19 was going to cause immediate reassessment of their home. It does not. So I want to be super clear about that. Nobody's property is getting reassessed except upon now, if it's passed down to a child, depending on how they're going to use it, there may be a reassessment that before they were excluded from. But your home that you live in is not going to be reassessed by the county because of Prop 19. And your rental property that you own, if you own rental property, it's not going to be reassessed by the county because of Prop 19. It's not designed to do that. It's designed to be helpful, especially to older homeowners. It's going to be very good for a lot of people in California. Who it's not going to help is their children, who now are going to inherit properties that, well, you inherited a property, that's nice for you, right? I'm not going to deny that that's a nice thing to receive, but you're not going to get, you may not get the advantages of the old regulations that made it very easy to own rental property or to rent out a home that was once your parents' and make extra significant profit off that because of the difference between the property taxes that you were paying every year and the high rental value of properties, especially in the Bay Area, as we all know. So those are some significant changes to how this is going to look. And there's a lot that we won't know until some of these things are tested in court, which will be interesting to see. I wanted to let people ask questions about Prop 19 if they had any.
I'm just wondering, hi, thank you for doing this presentation. I'm just wondering how is that going to actually work? So when I pass away and my kids don't want to live in my house, it gets reassessed if they want to rent it, right? So I guess the county finds out I'm dead, even though I have a trust. How do they find out I'm dead, first of all?
Yeah, really, really good question. Mhm.
And second of all, I'm sorry, second of all, how does it get reassessed and how does that get going?
Yeah, so these are really good questions. So I think this is a common misconception that we see sometimes. So people think because I have a trust and the property is owned by the trust, when I pass away, nothing changes. And that's not strictly speaking true, especially if what you have is the very common type of trust that most of us have, which is a revocable trust that becomes irrevocable upon your death. That's what you might know as a living trust. So what happens is when someone passes away, and let's assume for this scenario that we're at a point where that property is going to go to children, so we don't have a surviving spouse, because obviously with most trusts, if you have at least one of the two spouses surviving, it's just going to continue on as normal. There's not going to be anything that's triggered. But let's say it's the second spouse to pass away, and now we just have kids who are going to inherit the property. So a couple things happen. The first is, unless your trust is designed to hold the property in trust, and then they receive some sort of income from it for the rest of their lives, there's going to be at some point a deed that removes the property from trust and puts it in their own names, or maybe in the names of trust that they personally have because they have their own personal trust with spouses or something like that. So when we do that, anyone who's ever bought property may know that you had to fill out a form called a preliminary change of ownership report, or a PCOR, and that gets sent to the recorder's office, and then they forward that to the assessor to say, by the way, ownership has changed in this property. And you can't get out of doing that form. If you don't submit it, they send you the form to fill out, and then they charge you $20 for the trouble. So you do have to do that form. Secondly, even if the property is designed to stay in the trust, unless the property was transferred to an irrevocable trust, which is now the owner, technically when the person died, the trustee of the trust was supposed to send a death of real property owner notice to the assessor's office. So that's what lets the assessor know that the person has died. Usually depending on the timeline, a lot of times we do that form at the same time as we deed the property out of trust to the beneficiaries, but not always, especially if we're going to keep the property a bit long-term in the trust, or maybe we're going to sell it within the trust. But there is a form, and you do have a legal obligation to notify the assessor's office. A lot of times at the same time on that form, you're indicating that the property will be subject to the parent-child exclusion. And so you tell the county, by the way, you can't reassess because the property is given to my children under my trust. So they don't treat it as a reassessable event. But of course, there's a lot of, how to put it, there's a lot of openness about, or open-endedness about, if the original intention is to keep it and you file the parent-child exclusion paperwork within 1 year of the transfer, which for our purposes is date of death. And then 2 years from now, you end up moving out and renting it out. How will the county find out? Well, you probably have a legal obligation to inform them, but let's say you don't know that, because most people probably don't. I have had clients who got notices from the county, even when they weren't renting the property out, basically saying, we know this person died, it's been a year, we don't think you're living there, are you renting this property out? And then you're being asked to respond under penalty of perjury. So they do keep an eye on that. Whether they would know immediately, I think, is an open question. But strictly speaking, when the homeowner passed away, there was a notification process that goes to the assessor's office, and that's how they're finding out there's a change of ownership for their purposes. And that's even if the property is in a trust under your name.
So I was going to ask you too. So say, for example, you know, the irrevocable trust is, I suppose, a good idea, and that's something that we probably should contact you about. But say, for example, my son lives in Berkeley, and he would use this as a second home or rent rooms. Would that still qualify?
Likely not, because we're talking about it being the principal residence. So if he is the homeowner of another property and he's claiming that is his principal residence, you know, for...
It would be a rental, I'm sorry.
Yeah, so...
No, he's living in a rental is what I mean.
Oh, I see. So
Yeah.
that becomes an interesting question. When you file the parent-child exclusion paperwork, you're being asked to say, again, under penalty of perjury, that this is your principal residence. Look, the assessor's office is not standing outside the home spying on it to see if you spend more than 6 months of the year there, or if you're living somewhere else some of the time. The test is not whether you're generating any rental income, because from your primary residence, you could, of course, rent out rooms. You could have roommates who pay money to you to live there. There's nothing stopping you from doing that. The test is really, are you treating this as your principal residence, and are you occupying it in a way that leads us to believe it's the principal residence? How they're going to find that out, it's really hard to say. They may never sort of look into that too carefully. I would say certainly if that's the only real property you own under your name, you have a much better argument that it's your principal residence than if you own multiple pieces of property. So something to consider.
I had a question about the $1 million exemption. So if my property is inherited from one of the kids, but they're not going to live there, they're going to rent it out, is that where the $1 million exemption applies?
So before February 16th, yes. That was where you got to transfer both your principal residence and up to $1 million of other property without reassessment. That's one of the most devastating changes with Prop 19, is that now you can transfer your principal up to $1 million of value on your principal residence. So you basically get $0 of exemption on any non-principal residence. And again, it has to be the principal residence on sort of both ends of the transaction. It was yours and now it's theirs. The $1 million now refers to the idea that if, let's say your property is currently assessed at $200,000, but really it should be at 1.5 million because property values have gone up so dramatically. They will get up to $1 million excluded from reassessment, and then they'll be reassessed on the difference between $1 million and the actual value. So again, for a lot of people, that's going to be a really good deal because that $1 million is going to carry you pretty far. But they will reassess on the difference in value between your $1 million exclusion and the actual value of the property.
Yeah, we just ran into this thicket wicket because my father passed away in July, and it was the primary residence, and we also have commercial property. And with the ambiguity in the law, there was no clarification on whether they were going to look at date of death or date of actual transfer, right, of filing the transfer paperwork. So we jumped through hoops and we ended up transferring the property probably sooner than we would have normally in the process. You know, because our attorney was like, look, we have a lot of friends, you know, in the state business that are like, no, it's going to be by date of death. And then we have a lot of them say, yeah, no. And like, we don't want to tell you date of death and then find out that when it comes down to it, they're arguing against that. So yeah, that's what we did. I mean, and kind of under the wire, especially on the commercial property, because there were a couple of things we needed to do ahead of time. And then with the courts being pseudo session, right? As well as how not being able to walk into the county. And everything, we had everything in under the wire, but
yeah,
it's difficult not having that clarity.
Yes. No, you make a really valid point. And I should say for like that first 6 weeks after the election, we basically had no guidance whatsoever. And there were a lot of sessions for attorneys to attend, and they would have people from the assessor's office. And because the county assessor's office, for a large part, make their own rules about these things, except what they're mandated to do by state law, there was a lot of ambiguity there as well. Different counties were saying different things. So for example, I think it has now been sufficiently clarified that they will look at date of death for people who passed away before that February 16th deadline, but for a very long time, it wasn't clear. And it still hasn't been codified, right? This is the legal guidance from the BOE. This is what they say. I personally, reading what has been issued, I think they're going to look at date of death, but they may make the process more complicated than for those who got their transactions done before the 16th. I should also point out there are going to be a decent number of people. And again, this is because they let the counties make their own rules. There are some counties that have said, if you signed a deed before the 16th, even if that deed was not recorded before the 16th, we will consider that to be the date of transfer. There are other counties that have said the exact opposite. They have said, if you did not get your deed recorded by the 16th, by the end of the day on the 15th, then that does not count. And you may know this because the 16th happened to be the Tuesday after President's Day weekend. So the recorder's offices in a lot of counties were closed Friday and Monday. So Alameda County, for example, where I am, they issued something on their website that was probably not as prominent as it should have been, that said, your transactions have to be completed before end of business on, I think it was the 11th, because that's how the days worked out. And people who didn't have attorneys, or attorneys who didn't commonly check the website or didn't realize it was a holiday weekend, we're gonna have some cases where there are people engaging in long drawn out battles with the assessor's office that may end up having to go to litigation about the inconsistencies in the rules, and in fact, the lack of clear rules that were issued.
Yeah, because I know the other question that our attorney brought up was, what if it, and we're Santa Clara County, what if they receive it that day, but they can't process it because of their backlog? And does it go based on do they put a stamp and nobody knows? And I think, I'm not sure, because I know it went through because we've got notification, but I think they ended up using some sort of a service that has an agreement with Santa Clara County for e-recording.
Yes. And a lot of people turned to those e-recording services because they were the only ones that could guarantee certain dates. But you're absolutely right. There were very few, if any, recorders offices in the Bay Area that were open for in-person transactions, which is the way we usually guarantee a date. And either by mail, which most attorneys weren't using because of the problems with the USPS, as well as the lack of staff to open mail at the recorders offices, or the drop boxes that were provided, things were not necessarily being processed on the schedule. And none of these institutions guarantee that they will backdate things. They in fact, if anything, they say the opposite, although sometimes they end up backdating things if they've marked things as received on a certain day. So you're absolutely right. There's still a lot of ambiguity there. And there's still, for any transactions that took place on that borderline period, there's going to be a lot of ambiguity until the assessor's office makes a final determination in each specific case, or we get overall guidance that is issued, or guidelines that are issued that have to be followed, right? Regulations essentially that have to be followed. And I know there's been some requests to the legislature to do some rulemaking because Prop 19 was not as thorough in those areas as we might have wanted it to be.
And just in clarity, when you look at which I guess is going away or went away with the new law, with the $1 million for property other than the primary residence, is that $1 million of assessed value?
Yeah, yes, but the thing is, what it looks like they're going to do is they're going to say, and it seems like they're going to have to do this for every case because of this $1 million limit. They're going to have to say, if this was a purchase, this is the value the property would be assessed at today. This is the value it's currently assessed at. you basically get up to $1 million for free at the lower value. And then if it's supposed to be assessed at 1.5, then on the 500,000, they increase, or I'm sorry, they treat it as though the property is worth 500,000 assessed at today's levels. So this is what's a little bit confusing, because it seems like they've actually made more work on parent-child exclusion transactions about the principal residence, because before they only had to do this for the rental, the extra properties. Now they're going to have to do it for every property. But yes, it is about the it's about the assessed value, but they will be looking at it as of the date of transfer, which is for most people is going to be the date of death. What is the assessed value? And if that's over, $1 million, then the extra part will be reassessed.
Got it.
At least that's what we think so far. If they send out additional guidance, hopefully that'll be transmitted with clarity to the legal community so lawyers can properly advise their clients.
And one other quick little side note, because I just got this little email today from, is it San Jose Spotlight, Brian? Is that the?
Yeah.
They actually spoke at our club, and they do like a Q&A thing, I guess, occasionally, and they're doing one with oh, what's his name, Brian? Who's your old boss?
Very Stone.
Yeah. with the Santa Clara County assessor.
Yeah.
Specifically
perfect.
on Prop 19.
And if you are interested,
So anybody that wants questions in Santa Clara, that's the one.
yeah, no, and again, a lot of these things are highly county specific. So if you want to know how your county is going to treat them, that is the perfect opportunity to find out and get some clarity. And of course, if they say something that contradicts what I said, then that's probably how they're going to deal with it in your county, and you should take their word for it on that until they tell you something differently. Any other questions?
Okay, so Rebecca is in a noisy area, and I heard mine voice isn't that good over the internet.
You actually sound good right now.
No, okay. I don't know. Well, then why did my wife tell me to mute myself?
She's your wife, Brian.
Because yours echoes.
Oh, okay.
Yes.
So can Dave Olson, can you give us a heads up? And before Jennifer, thank you very much. This was perfect. This is exactly what we needed.
Thank you, Jennifer.
Thank you
Yes,
so
no,
much
great.
for
Thank you
having
so
me.
much.
And I think someone put my email in the chat. Thank you, Brian. I will put my office number as well. If anyone wants to talk privately or have questions they didn't want to ask in front of everyone, I'm happy to have a conversation with you individually about your specific situation. Normally I'd have cards if we were all there in person, and anyone could take one if they wanted one. So I'll just drop my information in the chat. Thank you.
Thank you very much, Jennifer. Okay, I don't know, Dave, is Dave still
Dave's
on?
not here.
Are you kidding me? He's not. And Rebecca's noisy, and I have no idea what the call was about.
Okay, well, I'll try. If it gets loud, I apologize. I'm going to go back on mute quickly. So basically, last night, the district governor and incoming district governor hosted a call with our RI Rotary actors, and announcing and sharing with us all the different things that are going on within Rotaract, but what they're struggling with is they don't know what to do next, right? And so they want to be a part of opportunities that are not just like at a sign-in table or like handing out stickers kind of thing. They want to be more a part of what Rotary is doing and have that full seamless transition of what it's intended to do. And so that'll be one of David's action items, if you will, coming in the new year as opportunities arise. And maybe Burke, I don't know if Burke is still on the call. Oh, I see. Yeah. And just to consider, because we just, don't want to just think about them, use them when we need them, but not really true considering them, excuse me, as our new members. Got it? Everybody? Yeah, I like it. Okay, thanks, Jerry. And Patricia. And Greg. And Jesse. Yeah, Jesse. So that was it. You could take yourself off mute. We can listen to you again.
So I was just going to say, also Toastmaster, I have a Willow Glen group that's been on our Facebook page, inviting me to their meetings, and I was going to try and go to one. It's really hard because it's at 7:30 in the morning, but I'll try. They have their Zoom meetings and everything, and see if we can get something going on between them and us.
I can do it at 7:30. What day of the week?
Wednesday.
Okay, have them include me on the invite.
Okay, I will. Okay, next, I guess that's about it. Who's our next speaker? Our next speaker is going to be, oh yeah, her name is Erin Dermet. She's a public information officer at the Bay Area Quality Management District, and she's going to talk about the nuts and bolts of Bay Area Quality Management District, spare the air day stuff. I heard her in another group. She's really good.
Sounds like a very expensive business card.
What?
That sounds like a very expensive business card.
Oh, what I just read?
Yeah, like title? Anybody? No, okay, whatever.
Okay. Anybody have anything else before we end the meeting?
Jennifer, thank you so much. Very insightful. I have your contact information because I'm actually currently in the situation that you're speaking about. And deadlines were not met and so forth. So anyway, thank you so much. We appreciate your time.
Okay.
Thank you all for having me. Nice to meet everybody.
All right, great.
Thank you.
Bye, guys.
See you later.
Good afternoon, everyone.
Bye.
Have a great afternoon.
Hey, sorry, dog's going crazy.